appears for the appellant and submits that the impugned judgment and order dated 4/4/2025 passed by the learned additional session judge special judge Pokso, Tinsuke in Pokso case number 5 of 2024 arising out of what is that PS case number? Arising out of Chengchu Chariali PS case number 23 at 2023, by which the appellant has been convicted under section 6 and
Of-
26
Six of-
bracket 3 IPC should be set aside. Admit the appeal, call for the trial court report, issue notice, returnable in 4 weeks. Miss A. Bingham, addition PP access notice on behalf of the state. Notice to be issued to the respondent number 2 to the OC of the concerned police.
PP officer. PP, Lordship.
To the PP that no notice be issued to the respondent number 2. To the PP and
PP office.
PP's office and the OC of the concerned police.
Lordship.
This is the matter of the court.
Obliged.
4 weeks.
4 weeks.
May it please, my lords. Lords, this is a statutory appeal by the informant against six were acquitted, 1 was convicted.
So you are against that acquitted.
Acquitted.
Paper book is already there, Lordship.
In item number 8.
So this will be heard together.
Yes, my lord.
Lordship.
One is against the conviction.
Yes, my lord.
Yes.
Conviction item number 8, my lord.
So we have to issue notice here.
My lord, paper book already ready, my lord.
Okay.
There is the order for expeditious hearing. You know, there is the order of.
No problem. So we can do it. But so the paper book
Lordship.
in that item 8 will suffice.
That will suffice.
That-
Yes,
Yes,
lord. Yes, my lord.
Let us issue this. Okay, right. Third, Mr.
MK Chaudhary.
M.K. Chaudhary, learned counsel
For the informant appellant.
for the informant appellant. Stop. This is an appeal against acquittal of 6 out of the 7 respondents. 6 of the 7 accused persons.
Yes.
Accused person. In relation to the judgment dated
22/12/2023.
23 passed by the sessions that on it for test court in sessions case number 105 of 2000. If you notice, returnable in 2 weeks, Miss A. Bingham, additional PP submit that the lone accused person who has been convicted had filed an appeal, that is criminal appeal 30 of 2024. He submits that the paper book that has been prepared with regard to the criminal appeal number 30 of 2024 can also be used for disposing of the present criminal appeal 247 of 2025. That's good. Mr.
My lord, in the item number 7, I am representing 2 and 3.
Mr.
PK data.
K. Deka,
For 2 and 3.
accept notice on behalf of phone number 2 and 3
Yes.
in criminal appeal 247 of 2025. What about the others?
My lord, already this number recorded 5 has died, my lord. Rest may take steps, my lord.
Okay. He also submits, no, Mr. P.K. Deka submits that the respondent number 5 has expired.
This recorded in this court.
Huh?
Already this number recorded on last occasion.
Not in this appeal.
Not in
May-
item number 8.
No. I think it was recorded in the IA
And
condemnation of delay. তাতে record
তাতে record
করেছে।
করছে।
It was recorded in the IA for condemnation of delay.
Okay, in this.
Yes.
Point number 5 is expired. So accordingly. So you make it returnable in 4 weeks then, because notice will have to go. Yes. So accordingly, the appellant shall take steps for service of notice upon the respondent numbers 4, 6, and 7 in criminal appeal 247 of 2025 within 3 days. This is a matter of 4 weeks.
Worship, when we met him with the Passover for some time, senior is in legs in court number 6.
But please,
You have challenged acquittal
Lordship,
within time.
Lordship, within time, Lordship. And there will be 6 number of accused, Lordship, and in this case, Lordship, one is convicted 7 years, and another 2, 3, 4, and 5, 6, and they are acquitted, Lordship. But otherwise, Lordship, as per the statement of the witnesses, Lordship, all they are equally, Lordship, involved in the alleged murder, Lordship.
Yes, what to do? Miss, Mr.
F.
F of learn for the informant appellant or what?
Informant applicant.
Informant appellant.
PCR may be called for.
Praise for setting aside the judgment dated
11/6/2025.
11/6/25 passed by the Court of the Election Sessions Judge FTC Saga in Sessions Case number 21 bracket S-S bracket close 2020 arising out of demo PS case number 20 of 22 by which the respondents have been acquitted of the charge under section 302
302 is Lordship.
302 IPC.
147, 148, and 302, Lordship.
140. Read with 147, 148 IPC. 149. 149.
Sorry, 149 is also. Lordship.
149. Admit the appeal, call for the LCR. Issue notice, returnable in 4 weeks. Ms. Gebera, additional PPXF notice from the other three. Appellant receives steps for service of notice upon the respondent's number 22.
So 2, 3, 4, and 5, 6.
There is no 6.
Lordship. 6 is there, Lordship.
Yeah.
Total. Lordship, page number 98, Lordship. Can you
No, in your petition, look at your memorandum of appeal.
Yes.
Look at the memorandum of appeal.
Lordship, sorry. 5.
2 to 5.
Five.
Step within, it is the matter of.
Deeply obliged. Obliged.
Yeah, please, your Lordship. Lordship, Mr. S. Dotto is legs in court number 10. Lordship, kindly timely, Lordship.
What is to be done here?
We have pray for interim order, Lordship. So, Lordship,
Interim order.
Lordship. Your Lordship, we are appearing on behalf of the respondent, but we have not yet received the copy of the petition.
Of the appeal.
Yes,
Lordship, appeal, today is the
today is the first day of the appeal. I was fine.
First day or the last day, they need a copy.
Lordship, but notice was not issued in the appeal, Lordship,
Okay,
because
that's
this is the date fixed for.
under section 498 bracket A IPC read with section 4 of the POCSO Act 2000. Next. We find that the appellant has challenged his conviction by the special court in the above matter under section 4 bracket 2 of the POCSO Act. Whereby he has been awarded the sentence of
20 years.
Huh?
20 years.
Rigorous imprisonment,
Yes, ma'am.
rigorous imprisonment for 20 years. With a fine of rupees 10,000, in default of fine to suffer simple imprisonment of 6 months. Next paragraph.
Lordship, in item number 12, Lordship, earlier notice was issued. As at that period of time, Lordship, it was not through practice direction, Lordship. So notice may be issued, Lordship.
It has to be issued. Notice is not issued.
In item number 8, as it is the same,
12.
12, Lordship.
So
Notice, I said that I like the second conclusion of the one.
that is okay. Notice is issued only to the state. Correct. Is there some private respondents here? In the memo of appeal, is there any private respondent?
My lord, so far this jail appeal is concerned, it's not there, and my
There is
friend
no
is saying,
private
but-
respondent.
and is in that, my lord, at that point of time, 22, my lord, 2000.
I know, so you have to, we will have to, issue notice to the OC, right? What have I said? Next paragraph. We also find that paper book has been prepared in respect of both the appeal. As the issue to be decided can be decided only in one appeal. Come on, we are of the view that criminal appeal 58 of 22 should be closed. And the legality of the impugned judgment passed by the learned trial would be decided in criminal appeal day of 2020. Next paragraph, 15. We also find that no notice has been issued to the victim or the guardians of the victim. In terms of guardians of the victim in both the appeals filed by the same according in terms of the other parts in front of dash, just a dash. We issue notice to the victim will be how old now?
She, my lord,
She'll be, I think, major by now.
yes, my lord.
She was old.
Daughter, my lord. So mother will
Or
receive
will
the
issue notice to the
mother of the victim. Informant,
father slash mother,
the father is the.
Accused,
mother slash guardian
Lordship.
of the victim. Through the PP's office,
Lordship.
through the PP's office and through the OC of the concerned police station.
Lordship. No, I'm not sure.
You take.
Yeah.
What about the step, madam? Step,
Lordship, actually, Lordship, they will have
provide the thing.
provide the copy to registry. Registry will provide to our PP office.
But I'm an amicus curiae.
So registry will take the step, Lordship.
Registry to,
Furnish a copy to the PP office.
it will be what copy? It will be a soft copy.
Lordship.
You know, it doesn't have to be a hard copy.
No, Lordship. Soft copy.
You know,
Soft copy will also do that.
is a hard copy required?
Oh, otherwise this paper book may be.
Paper book may be furnished without,
Ah,
without.
no.
That will.
I don't know,
Or to give the information that our appeal has been filed.
Last-
With the number,
Huh?
with the number of appeal number, that an appeal has been preferred.
Registry to provide a copy of this order
Lordship.
along with the appeal petition
Lordship.
to the office of the PC,
Lordship.
who shall thereafter transmit it. Who shall thereafter forward the same to the OC with the concerned police station for taking steps of service of notice. This is the matter after court. I am obliged. So we have closed one.
Lordship. 12 is closed.
Lordship, case is ready for hearing.
Ms. B. Sharma, learned counsel for the appellant. And Ms. A. Begum, addition PP, submit that they have been given copies of the paper book.
Lordship.
Accordingly, release this matter for hearing individual.
Obliged.
Well, by order with 8/1/25, my lord, amicus curiae was appointed, my lord, for respondent number 2. And accordingly, office was directed to serve a copy to him, paper book, my lord, and to show his name in the cause list, my lord.
Okay,
Name is also not shown in the cause list, and whether copy has been served on the amicus, that is also not available, my lord.
okay,
Ordered at 8/1/25, my lord.
you're right. Mr.
As Mukhtar, my lord.
S. Mukhtar appearing on behalf of the appellant.
Fine.
And Ms. A. Begum, addition PP, submit that they have received copies of the paper book.
Lordship.
There is nothing to indicate that the learned amicus curiae.
On Arnav Das has been appointed. 8/1/20
Pranab Das.
Arnav Das, my lord.
Pranab Das has received a copy of the paper book.
Well, he has not received, there is no information, my lord. Whether he has been served, there is no information.
That's what I'm saying.
Yes.
Has received a copy of the paper. Registry to verify the date. And
Reflect.
To show his name, my lord.
we verify the same. And make a note with regard to whether the paper book has been given to the amicus curiae for the respondent number 2.
2, my lord. To show his name in the cause list.
His name should also be shown in the court. This is the matter after.
2 weeks, man. All right.
I think this thing, notice is complete.
Item 15.
As I said, notice complete as per office complete.
Lordship.
So out here, the paper book has to be made. Right. No one appears. Oh, wait, what is happening? Why is this file no? Jail appeal, oh, we've got to appoint a. Amicus.
Amicus. Copy is also not furnished to us, Lordship.
No, they have got to make, they have not made it.
Lordship.
Tell them to. Who do we appoint?
Is that us and also there, Lordship?
Huh?
Meghali M. Bormon is there, Lordship. He can be. And Vivekananda is also there. B.N. Gogol, Lordship. Dr.
Meghali.
Gogol. He-
Right.
B.N.
Khalid
Gogol.
Burman is appointed as amicus curiae in the district. Registry to prepare the paper book. Yes, the PCR has, right? This is the matter. After 4 weeks. 17.
Your lordship. As far last.
Say one thing, office note also indicates that notice has been served upon the respondent number 2. Yes, item 17.
Yes, lordship.
Here also same thing,
Yes, lordship. Completed, your lordship.
I think notice has been served on respondent number 2.
Yes, lordship.
So paper book
Lordship.
Paper book will be
to be
prepared.
prepared.
Objection also filed, Lordship.
For what? Actually, with regard to that,
Yes.
so we can decide that 430 application.
Lordship.
What?
Lordship, paper book may report
Evidence are required.
So there's no objection filed in the thing.
Option for like.
Anyway, right, in the appeal, you write. Registry to prepare the paperwork. The office note indicates that notice has been served upon the respondent number two. List the matter after preparation of paper. Then in the IA, right? And this is an application under section 430 bracket 2 BNSS for suspending the sentence and releasing the applicant. No, objection is not here. We don't have. Not here.
Yes.
You have not filed. You have got a copy,
Yes, Lordship. It was filed on 9/1/2025, Your Lordship.
but it is not here in the IA. Have you filed, madam?
Lordship, B. Bhuya have filed, Lordship.
Has filed.
Yes.
Filed, there is Lordship.
Okay, right. The counsels for the parties raise that, submit that. Written objection has been filed by the state. However, the same is not on the copy. What is the filing number?
We don't have filing number. We have good.
If it was filed in January, till now it is not here in the record for to do. Registry to verify and place the same in the record, if not defective.
Lordship.
This is the matter of folder.
All right.
May please, Your Lordship.
Yes,
Lordship, notice is served upon respond number 2. Lordship may kindly see the office note.
okay, yes.
Last.
What about paper book has to be made?
Trial court record has been received. Paper book is to be prepared, Lordship.
Prepared. And written objection has been filed,
Yes, Lordship. I've got the copy.
right, in the appeal, you write. Registry to prepare the paper book. Office note indicates that notice has been served upon the respondent. This is the matter after preparation of paper book. In the IA, right? Written objection has been filed to the application under section 430 BNSS. This is the matter after following.
Amicus may be appointed, Lordship,
For respond number
for
2.
respondent number 2.
Since
Not
they have not
reported.
appeared.
Why? If she doesn't want to appear.
Lordship.
You see, there is no hard and fast rule. That just because
He is not appearing.
she is not appearing it's only in cases where notice cannot be served
Lordship.
that, you should appoint. Otherwise, if they don't want.
Don't want to appear.
Lordship.
Because they can always come and say, we do not have the means to engage a lawyer,
But-
then we'll give them, no problem.
Yes. And registry may be directed to prepare the paper book.
Otherwise, this is in the main case already. we have-
Main case, Lordship.
What have I said in the IA? It is a matter of. Oh, you want to dispose it off now? 430.
No, Lordship. Later, Lordship.
May I please, Your Lordship? Lordship may peruse the office note dated 24/2/25, Lordship.
Office not dated?
24/2/25, Lordship.
So? Notice has been served,
No, Lordship.
not served.
We have taken steps and thereafter the registry
No, notice has been furnished
furnished to
to learned
TV,
entity
Lordship.
and the receiving has been taken. Okay. What is the,
Lordship, earlier it was taken by KK Das, Lordship, my learned friend. I'll inquire the matter whether.
okay, right. Item 19, right? Registry to prepare the paper. Miss A. Bigam, additional PP shall obtain instructions as to whether notice has been served upon the respondent number 2. List the matter. After?
4 weeks.
4 weeks. Okay, 4 weeks. Registry to prepare the paper book within.
In the meantime, Lordship, they will file their objection.
What about the IA?
Their objection not yet filed, Lordship.
And then the IA, right, Miss A. Begum. Addition PP is granted. 4 weeks time to file. Written objection.
Deeply obliged.
I think 20.
Yes, what is to be done
Lordship.
here?
Yeah.
Paperwork has to be made.
Has to be made. And Lordship, actually, with this criminal appeal, we have also filed one IA actually for under section 410. And it was heard on last 18/6. And unfortunately, on that day, because she is a 65 years old lady, she was hospitalized to the GMC. So we requested that she may be given a bail actually. That's the, as of now.
This is a murder case.
Murder case, yes.
How many people were arrested?
Arrested was 5 actually.
How many
4,
convicted?
only one, mine only.
Who are you, the mother-in-law?
Yeah, yes, mother-in-law.
You're the mother-in-law. This
No,
is
no,
this-
huh? Objection has not yet been filed actually, right now.
Look, right, item 20, you write, item 20. Registry to prepare the paperwork. This is a matter after 3 weeks. Then in the IA, you write. In the IA, you write, Miss A. Begum, addition CP, is granted 3 weeks time to file an objection to the application under section 4 BNS. This is a matter of the choice. Okay, make it 4 weeks.
21.
May I please the lordship?
And yes, 39 days.
39 days then.
Madam,
No lordship.
correct. Third, Miss BRA Sultana, Senate legally counsel for the applicant, who submits that there's a delay of 39 days in the appeal. Miss A. Begum, additional PP, submit that she has got no objection if the delay is complete. In view of the submissions made by the counsel for the parties, the delay of 39 days is confirmed. Registry to list the appeal after a week. I is accordingly allowed and disposed of. 22. Yes, madam, any objection?
No lordship.
Right. But Miss,
Lordship, it is 720 days.
does it matter?
Lordship,
Criminal matter.
lordship.
But Miss
And Hassan.
N. Hassan, learned counsel for the applicant, who submits that there's a delay of 721 days in filing the appeal. Miss A. Begum, elected PP, submits that there is no objection to the delay being produced. Next part. On considering the submissions of the parties and keeping in view the reasons for the delay, we find that sufficient cause for the delay has been made up. Accordingly, the delay of 721 days in filing the appeal is condoned. Registry to list the matter after a week and is accordingly allowed in the court.
Highly obliged lordship.
23.
My lord, in this appeal, there is 26 days delay, my lord.
That same order as 21. Same order as 21. Parties are same also, I mean, lawyers same for them. 26 days.
24.
Much obliged.
Same order, madam. Yeah, this also is item 24 will be same order as 22. Okay. 1065 days. Okay. Your name?
M.A. Chaudhary.
M.A. Chaudhary, for the applicant. Okay.
25.
Deputy Officer.
Lordship,
And Hassan, okay, same
66 days.
66 days. Okay, same.
Obliged.
26.
May I please, my lord? This is a matrimonial appeal and there is a delay of 53 days while preparing the appeal.
What do we do?
So, my lord, I may be allowed to take steps, delay coordination petition.
Right, right, Mr.
Be
Be
the
the second. to submit that there is delay of 53 days in filing the appeal against the impugned judgment and order dated 4/4/2025, passed by the Principal Judge Family Court Number 1 at Kamrup M. Wati in FC Civil Number 822 of 2020. Issue notice returnable in 4 weeks. That the applicant to take steps for service of notice upon the respondent by registered post within 2 days. This is
Deeply
a matter of course.
Deeply obliged, my lord.
Maybe there was six. The appellants are convicted on the 302, 341 and 34.
Just a minute.
Right.
Three zero two,
341
341.
and 34. So,
How many appellants are here?
4. 10 witnesses. Man.
How many accused persons were there initially?
So this 4 only.
Four.
They are named in the affair.
Any eyewitness?
3 men.
3 eyewitnesses.
3. Now what happened, my lord? The deceased, the prosecution story, my lord, the deceased along with PW 1, 3 and 5, they went to the house of one of the accused, my lord, Upendeka, to get a battery, my lord, to run the CD player so that they can watch a movie. The person,
Just a minute. The deceased with
PW 1,
1, 3 and 5
3 and 5, this
went to the house of,
Upendeka,
who is he?
one of the accused, my lord. One of the convicts.
Okay, Upendeka.
Yes.
Yeah.
They did not find Upendeka in his house. When returning back, they were assaulted by the convicts. This is the prosecution story. A defense tried to build up a story by
No, you had gone to Upendeka's house to do what?
to get a battery,
Where a battery?
so that they can watch a movie on the CD player. Man.
To watch a movie where in Upendeka's house?
No. They went to Upendeka's house to get a battery on rent so that they can watch a movie
Then while coming back, you were beaten up
by these 4 convicts.
4 convicts. Okay.
This is the prosecution story.
Upendeka also.
Yes.
Probably you went to beat up Upendeka. He was not there. You all got beat up. Well, good.
Now the defense tried to build up a story. Man.
Yes, that is the story.
They tried to build up a story that these 4 persons, the victims, they went to collect some money which they have demanded from Upendeka, and the villagers, they caught hold of them, and in this tuffle, this is expired. There are inconsistencies, contradictions, my lord, in the witnesses. My lord. I will try to point it out while deliberation. My lord, for FIR, my lord, will find at page 4 of the paper book. My lord.
Yes.
The accused persons, my lord, Upendeka, Munna Deka, alias Harekanta, he is also known as Deepak Medhi. Kondorpo Deka and Rangabura, also known as Torun Medhi, my lord.
No, no, it's not written here.
No, that we will get it from the page 4. Page 4, that is the commitment order, my lord.
Page 4 is the FIR.
Oh, page 9, I'm sorry, page 9. Upendeka, Munna, alias Deepak Medhi, Kondorpo Deka, and Rangabura, alias Torun Medhi.
Just a minute, I'll just say. Upendeka is also known as?
No, Upendeka is known as Upendeka itself.
Then
Then Munna Deka, also known as Deepak Medhi.
Munna Deka. As?
Munna Deka is alias Deepak Medhi. Kondorpo Deka,
Deepak.
Deepak Medhi.
E.
DEEPAK.
Deepak.
DIPAK. Deepak
Deepak
Medhi.
Medi. Monu Deka.
alias Deepak Medhi. Thirdly, Kondorpo Deka.
Kandar.
Fourthly, in the FIR, you'll find the name is wrong.
Kandarpa Deka is known as what? As Kandarpa Deka.
Yes, well.
And then that Rangabura.
Rangapura, Torun Medhi. This will be clear from the commitment order, committal order at page 9.
Yes.
So they are the accused, they are the convicts before your lordship. Now, FIR reads, my lord, humble submission is that around 6 p.m. on so and so, 4 boys, namely Sonaram, Bisitra, Nizam Boro, and Pradip Boro. Pradip Boro expired, my lord.
Who expired?
Pradip Boro.
Pradeep.
Sonaram is PW5. Bisitra is PW1.
Yes, Peman.
Man.
PW. One
Sonaram
is
PW1 is Bisitra. Here number 2.
Vijitra Boro.
Bisitra Boro.
Then number 3 is
Nizam Boro, he is PW3.
and 5.
No, only 4%, madam.
No. You said PW5 is there.
No, PW5 is Sonaram Boro, madam.
Tandaram Boro.
Sonaram Boro, the number 1 in the FIR. PW1, PW3, and PW5, along with deceased, these 4.
They went to the house of doing a factory on rent.
Yes,
So he was renting factory.
Upendeka.
Upendeka was renting that.
He had one of these source of income. As they did not find the members of Upendeka's family, they came back. On their way back, the accused person assaulted them with sticks. As a result, Pradip Boro became unconscious on the spot, though he was immediately shifted to Bangapur Hospital. The doctor referred him to Guwahati Medical. Now it is learned that Sri Pradip Boro succumbed to his injuries in Guwahati. 3 persons lodged the FIR, my lord. 3 persons lodged the FIR.
This person.
They are from the village itself.
So this one is Mridul Pathak.
He is only he has been examined as a witness. The rest 2 are not. 6. Cousin.
Yes.
My lord, I will take lordships to the PW1, my lord, at page 10.
Page 10.
10.
Yes.
May I read it, man? I know the accused persons. I knew this is Pradip Boro. I also know the informant. The incident took place about 2 years ago. It took place around 6 p.m. As there was a ceremony in our house on that day, I went to the house of Upen looking for a battery. But when I did not find anyone in the house of Upen, I returned home. On my way, I met Deepak. He was in an inebriated state and hurled abuses on us. A fight ensued. Thereafter, Kandarpa and Deepak assaulted Pradip Boro. On seeing them engaged in a fight, I went to my house. They assaulted Pradip and failed him on the road. When Pradip fell down, we got frightened and therefore we went to the village and informed the villagers. Later, the villagers came there and found Pradip lying on the road. At first, Pradip was taken to Bangapara.
Just a minute. Who is the deceased? Name of the deceased?
Pradip Boro.
Pradeep. PRA.
PRADAP.
Pradeep Boro.
Boro.
I met Deepak. Deepak is
One of the convicts.
Munna Deka.
Munna Deka. In the evidence part, they are shown as Deepak Medhi. Skipping that part, Malak. Now coming to the cross. Police recorded my statement 1 week after the incident. It is not a fact that I did not state before police that Kondorpo had assaulted Pradeep. When we went to the house of Upendeka, there was no person in his house. Upendeka hails from a village inhabited by people of Assamese community. Our village is inhabited by people of Boro community and is located 1 kilometer away. Well, like, this part is important. It was dark at the time of the incident. When I raised the alarm, the villagers gathered there. About 550, 100 people gathered there. I did not notice as to who had assaulted whom. There is no electricity at the place of occurrence. We took the deceased to the hospital. It is not a fact that I did not state before police that I had taken Pradeep to the hospital. But here he says that he had seen all these persons fighting. But in the cross, he have stated that there is no electricity and I did not notice as to who had assaulted whom. That part may be taken care.
No, but you see, in the night, if dark, maybe there's no electricity. You mean to say everyone was fighting blind, hoping that one lucky blow would land here and there? You have walked in the night somewhere around the road somewhere. There is some light all the time. Not that it is pitch black, dark, you can't see anything. Ah.
It is not a fact that we had demanded an amount of rupees 2 lakhs from Upendeka and that when we went to bring that money, Pradeep was assaulted. It is not a fact that we fled the scene while the villagers assaulted Pradeep. Upendeka lodged the case against us. It is not a fact that I have deposed personally department.
Upendeka is the real, the deceased.
Convict.
Convict.
PW2, madam. He's one of the friend of the victims. Well, he was not there.
He was the friend of the victim, but he was hitting the victim of.
My lord. My lord.
He was the friend of the victim,
Yes.
but he was amongst the attackers also.
No, he was not amongst the attackers. Madam. He was in his house. Then when the attack began, madam, the victims ran and informed him. Madam. I will read it, madam. I have recognized the accused persons. I knew this is Pradeep. I also know the informant. The incident took place about 2 years ago. It took around 8 p.m. The time also they vary. All the witnesses, the time is different. The first PW was said, it was at 6 p.m. Now it is 8 p.m. I was in my house.
This Bichitra Boro is an eyewitness.
Bichitra Boro, yes. He also went to bring the battery. Thereafter, the assault began. Bichitra and Nizam went to our house and informed that Upen, Kondorpo, Torun, and Deepak were assaulting our companions. They said that the above named persons were assaulting Pradeep. Then I went there in a run and saw that Torun was assaulting Pradeep by tying him up with a rope in front of the house of Upendeka. After arriving there, we untied the knots and took him to GMCH. Later, we came to know that Pradeep had died at the Guwahati Exhibit 1212. The cross court matter. Police examined me on the following day of the incident. It is not a fact that I did not state before police as well as before magistrate that Torun had assaulted Pradeep by tying him up with a rope. Our house is near the place of occurrence. There are houses of many other people near the place of occurrence. Nizam Boro went to my house from the place where the incident of assault was taking place and informed me about the incident. It was around 8 p.m. when I reached the place of occurrence. When I reached the place of occurrence, some 4 people were present there. It is not a fact that Nizam, Pradeep, and Bichitra had demanded money from Upendeka in the name of Boro organization. It is not a fact that when they had gone to demand the money, the villagers kept Pradeep tied. It is not a fact that when Pradeep was kept tied, he tried to flee and by falling down, he sustained injuries. Now, there are contradictions in this part that has been proved by the IO regarding that assault by
There's
Torun.
so many names, I have to get used to these names. This Ranga Bush is Tarun Medi.
Torun.
Torun Medi.
Yes.
Munna Deka is Deepak
Deepak.
Medi. No, let us see. Let's get used to these.
The four persons, both sides. Inform victims. Victims were the deceased and PW1, 3 and 5. PW1 is Bichitra Boro, PW3 is Nizam Boro, PW5 is Sonaram Boro. Now the convicts, my lord, are Upen Deka, Kondorpo Deka, Torun Medhi, and Deepak Medhi.
But Deepak Medi's name is Munna Deka
Yes, yes.
and Tarun Medi.
Only in the FIR that Munna Deka is reflected, my lord. The rest of the evidences, my lord, it is Deepak Medhi.
Then
PW3, my lord, page 15. He is one of the victims, my lord. Nizam Boro. I know the accused persons. I knew this is Pradeep. I also know the informant. The incident took place about 3 years ago. It took place around 10 p.m. We went to the house of Upen to fetch a battery in order to watch a movie with the help of a CD player. Upen was not in his house. Upon finding no battery, when we were returning and reached the road in front of the house of Upen, we saw Kondorpo, Deepak, and Upen assaulting Pradeep. After tying him up, the accused persons tied the hands and legs of Pradeep and assaulted him. Then we went and informed
they
the
saw Kandarpa
Kondorpo,
and
Upen.
Upen. They did not see Tarun Medi.
Yeah, they did not see. This is they saw, and in the cross part, my lord, you'll find it was dark at night at that time of the incident. I raised alarm. About 50 persons gathered there. I did not know as to who had assaulted whom. Only the fight went on. Amid the fight, we slipped out and informed the villagers. Pradeep also ran, but he fell down as someone assaulted him. I do not know as to who assaulted him. It is not a fact that we had demanded money from Upendeka. It is not a fact that on the day of incident, when we went to fetch the money, the villagers assaulted him. The defense is trying to build up a story, that story that they went to get the money that they have demanded from Upendeka, and the villagers got hold of him, and in the tussle, my lord, he fell. PW4, my lord, he is the father of the deceased, my lord. He is a hearsay witness, my lord.
So no point.
No point.
You are appearing for?
I am appearing for two appellants, my lord, Upendeka and Kondorpo Deka.
Okay, what about the other person?
Torun Medhi and Deepak Medhi, my friend is appealing.
Okay. So there are two appeals.
No, one appeal.
One appeal and you're dividing the party.
No, we're not segregating it, we'll place it together.
One appeal. Yeah, supposing in one appeal, there are 100 appellants. Supposing each appellant engages one lawyer and files a consolidated one appeal. Same thing you're doing here. How can,
My lord, I'll add up.
why should you let that one say everything? Why should we allow?
I will cover all the portion, man.
What is this? You should have filed your own separate appeal.
No, my lord, PW5.
In the beginning, we were in this appeal, my lord. In the beginning, we were in the appeal, my lord. And
Later, my lord, these two appellants, my lord, approached me to appear on their behalf. No, we are placing it together. Together, man.
Four accused are there, Lordship.
We place it together, man.
Two have engaged them and two engaged us.
One appeal.
Yes, my lord, that will not make a difference, my lord. We'll place it together.
But I'm just saying that it's not usually done.
Not
Yes.
usually done.
No, we will place it
Yes,
together.
so many writ petitions. In the writ petition, sometimes there are 20 writ petitions on the same cause of action.
Lordship.
Say, seniority. Then we cannot allow 20 lawyers to represent 20 writ petitioners in one writ petition.
He will repay.
I'm submitting. Page 20, my lord, PW5, man. Page 21, PW5, my lord. He is the cousin of the deceased man. He was also there. He also went to bring the battery, man.
I know, may I read it?
This,
I know the informant Middle Pathak, Rakia Boro and Robin Sargari. I know accused Upen, Kandorpo, Deepak and Torun. People address accused Torun as Rangbora. This is Pradeep Boro is my uncle's son. This is was my elder brother. The incident took place about 4 years ago. It took place around 6 p.m. It was yet to be dark then. The incident took place.
was yet to be done.
Yes. He says 6, man.
Yes.
Yes, yes.
One earlier, said six.
When did it occur? Which month?
In the month of March.
March. So March, what time does the sun set?
Normally 6, man. Yes, yes. It was yet dark. The incident took place on the village road of Santipur village near the accused Kondorpa's house. At the time of the incident, Bisitra Nizam, deceased Pradeep, and I were present together at the place of occurrence. The accused person assaulted Pradeep Boro with their hands and sticks. The accused person dealt with blow on the head of the Pradeep, as a result of which his head got fractured and blood came out. This is something not consistent with the medical fractured head and blood coming out. Pradeep fell down on the ground as a result of the blow. Out of fear, I remained silent. Nizam Boro and Bisitra Boro fled out of fear. After committing the incident of assault, the accused persons ran away from there. When Nizam Boro and Bisitra informed the villagers, they took deceased Pradeep to Bangapara Hospital. The hospital referred to GMC. Now coming to the cross partner. Police recorded my statement on the day of incident. The magistrate recorded my statement about 3 days after the incident. It is not a fact that I did not state in my statement before police that the incident had taken place near the house of accused Kondorpo. It is not a fact that I did not state in my statement before the police that the accused persons had assaulted Pradeep with bamboo sticks. This is hitting with bamboo sticks, my lord, that has not been stated before the IO, my lord. That will come later, my lord. And the bamboo sticks are not seized, my lord. The weapon is not seized. It is not a fact that I did not state in my statement before police that Pradeep's head got fractured and blood had come out. At the time of incident, light was fading away, but there was visibility. Houses of other persons who are there near the place of occurrence, I did not run, but 2 of my companions ran away from there. Later, other people came to the place of occurrence. It is not a fact that Pradeep fell down while running and sustained injuries. It is not a fact that I have deposed falsely. PW6 is the informant, my lord. He also was not there, my lord.
So how many witnesses? The PW?
10.
Total 10, my lord.
No. So how many eyewitnesses? PW?
PW1
1,
and 5.
1, 3 and 5.
They are the victims, my lord. They went to fetch the battery and then the fight took place. This 3%, PW1, 3 and 5.
Upendas was not involved.
Well, it is the story of prosecution have said that he is also involved.
Prosecution said he's involved.
PW6 is the informant, my lord.
So why should he be involved? Can you give us some idea?
My lord.
Why was Upendas involved?
He's involved. It is because, my lord, the discrepancies, I will point it out, my lord, by taking the other evidences, my lord. These contradictions, my lord, were taken to be minor contradictions. But these are major contradictions, my lord. My lord will see through it, my lord.
You all went to borrow a battery from Upendas.
No, the victims went, man. Victim went to the
The victim went. The victims went
yes,
to Upendas
to get
to
better.
get the battery. While coming back, you all hit them.
That is the prosecution story.
Upendas is also amongst them.
Yes. They say, my lord, Upendas in their 164, which they have not stated in their evidence, my lord. In their 164, they said Upendas tied the hands of everyone. But that is missing from the evidence part. Probably they forgot what they have said in the 164, that they were being tied by someone. They forgot that part. In their 164, it is said, everyone says, Upendeka tied everyone's hand at the back.
Probably, those persons had gone to beat up open data.
Yes, sir. To get the money, my lord, actually. Then villagers caught hold of them, my lord, then some tussle took place. There is in the medical evidence also, we got a medical evidence, 2 injuries, my lord.
We have to go only by the evidence. We
Yes,
cannot go beyond that.
PW6 is the informant, he is also hearsay, my lord, nothing much.
So basically 1, 3 and 5 only.
1, 3 and 5.
And then the medical report.
Yes.
He also says, Lordship, in PW2 Lordship,
Uh,
he also says PW2 page number 14 Lordship. Page number 14. Then I went there in a run and saw that Tarun was assaulting Pradeep by tying him with a rope in front of the house of Upendek.
That is improved. Well, I will take your lordship to page 90. That is the 164 statement of PW2, Alamba Ramsey. Page 90.
according to you, how did this person die?
Yes, but the medical evidence will make it
How
clear.
did Pradeep Boro die? So you, according to you, you never met Pradeep Boro that day, is it? According to you.
In 313, my lord, only in 313, Upendaka has taken this plea of alibi, my lord. But
What alibi?
that he was in his uncle, maternal uncle's place. But
And
only
what
in
about
313,
young
I cannot.
Beyond? Did you see the disease on the day he died?
I'm sorry, your lordship.
Did you see the disease on the day he died?
The
Others?
Yes, yes. They came to take money from us. And the villagers got hold of them. 3 of them fled away. One, he fell down and he got injured in the head. Medical evidence, my lord.
Yeah.
Now, as my lord have read, my lord, PW5, he have said that it got fractured and blood was oozing out. My lord, the inquest report, the one who have conducted inquest, my lord, does not say about the blood coming out.
Blood
Page-
coming out from whom?
Coming out from the head of Pradeep, my lord. Page 28, my lord. That is the person who conducted the inquest.
Page 28.
28 is the evidence of the person who conducted the inquest. On 2/3/2010, I was ASI attached to the Mangobar, and as that I held inquest over the body of one Pradeep Boro, aged so-and-so, son of so-and-so, village so-and-so, Baksha. In the inquest report, exhibit is my signature. The inquest report was prepared in the presence of presence. After inquest, the dead body was sent to
Let
the
us see the inquest report. Why
It's 96. 96.
Yes.
Second paragraph, madam. First paragraph is the body is covered with a white cloth and is lying on an iron bed in the CD ward. The hands and legs are lying straight. Eyes and face are slightly open. Hair is 3 inches long. Wearings of the deceased comprise of a pair of jeans, trousers, and a jacket. Black mark is seen in the right eye, and the injury is seen above the left knee. Now, upon turning the head, turning the dead body over again and again, no excreta is seen in the private parts. Now, in order to ascertain the actual cause of death, the dead body is sent to the police station sergeant along with the relevant hall for the performing name and address. Now, it does not speak about the blood coming out.
You don't expect blood to come out
It
throughout.
is in their evidence. They have said that
You see, this inquest was done where?
at that place, at the hospital, man.
A hospital. And the injury occurred where?
Well, that's human blood.
What was the time difference?
Yes, that I.
Just because blood came out doesn't mean that it will carry on flowing like the Niagara Falls. Will continue. It has to stop.
Yes. But the way it has been said,
You can show that the time difference between body being in that place of occurrence and the hospital was very, very short. There also, how, you must have a cut in your hand sometimes. How long does you think the blood flows?
but if there is a fracture in the head, my lord,
You tell me how long does it flow?
but if there is a fracture in the head, the blood has to be there, my lord.
How long? How
No,
long?
yes,
How long?
my lord.
How long will
How
it?
long?
How long? Do you think that it will carry on flowing? How long?
Now, the medical evidence, my lord, says it is contused. Contused is, the dictionary meaning is without breaking the skin. If there is no breakage in the skin, then blood cannot come out. Well,
Let us see the medical.
medical,
report.
my lord, 29, page 29.
Page 105, postmortem report.
Yes, postmortem report.
Postmortem report, my lord, 100, my lord. Start from 100. Postmortem report, my lord, page 100. Starts from page 100. External appearance, am I with the lordships?
Yeah.
External appearance, condition of the wounds, position and character. One linear abrasion over the left upper chest. One linear abrasion over the right upper chest. The linear is something that marks. You don't get linear abrasion by way of hitting by a bamboo stick or beating by with the hands.
The next page.
Scalp grossly contused all over. Skull depressed fracture frontal lobe 5 to 3 cm. Fracture at the frontal lobe on the right hand side of the temporal bone. The membrane is congested. Now what I am trying to
Carry on reading. Why is it stop?
there is nothing. Brain and spinal cord. Brain laceration.
Oh, the membrane that.
Membrane congested external hemorrhage right frontal lobe.
What does hemorrhage mean?
Hemorrhage means there is
Hemorrhage means what?
blood clotting. Madam.
Hemorrhage means blood clotting. Are you sure?
No, hemorrhage is
Blood clot is a blood clot. Hemorrhage means what?
get bulged out.
Ask Dr. Google or your Uncle Google. What do you call him? Ask him what is a hemorrhage. See, when you hemorrhage, that means you're losing something.
You got a hemorrhage to some dictionary.
Ah. Sometimes you ask Uncle Google, he's got a good dictionary.
Release of blood from.
Ah.
No. This is hemorrhage. This is bleeding. It's bleeding. Hemorrhage to some.
He was hemorrhaging blood. Hemorrhage means blood. Unless he was hemorrhaging apple juice or something like that.
Huh? No,
It's a loss of blood.
Loss of blood, hemorrhage is loss of blood. That's all.
Bleeding can be trapped inside the.
I'd like to point out one part of the cross-examination of the informant, my lord, at page 25. One part. Page 25, that is the evidence of the informant.
So you've got the definition of hemorrhage now. Meaning of hemorrhage you've got. Have you got?
Loss of blood. Now, how that is affected, man? How the injury got? How he sustained the injury, man? Page 25, man. Witness volunteers. The companions of the deceased informed us that the accused person had tied the hands of Pradip Boro from behind and then hit him on the back of his head with a stick, thereby causing injury to him. Now here the injuries are in the frontal bone and the temporal bone, my lord. and the postmortem report does not suggest that there is injury at the back. They are saying that they were hit. He was hit
You
by a
see,
stick.
these things as to whether, you see how action or movement is perceived.
Yes, yes, that is there.
It-
Angle may differ.
Depends upon a lot of things. Okay, you see a person hitting, so you might think that he's hitting in the back of his head or the side of his head, but it may be actually the front of the head also. Might be not even the head, might be the shoulder also. You cannot say. You
It
cannot
is
say
stated
for sure.
hit him on the back of his head.
That's how he perceived it. It's not accurate. Don't expect everything to be accurate. Nothing is very accurate. Like you see, you see sometimes a boxing match. You see someone punching. You think that you have punched the stomach, but actually they have punched slightly below the stomach also and they fall down. Or sometimes they punch, so how we perceive might not be as accurate as actually what happened.
And one more aspect, who made the blow? That is not clear for me.
Okay, maybe. But common intention was there to do something.
Well, that requirement is that there has to be a meeting of my minds prior to, it has to be pre-planned prior to the incident. From the evidence, there is no suggestion, not a whisper that there was a meeting of minds prior to the incident.
This conviction was done under 302 only.
302, 341. 341 is keeping unauthorized.
Only possible.
I'm sorry.
Keeping one person.
Yes, keeping unauthorized.
34 also must be there.
34 is there, but 34 will not attract because I said there is nothing to say proof from the evidence that there was meeting of minds. There is any pre-planned meeting of minds. For common intention, madam.
Right? Why?
I'm sorry.
Because they went to collect battery. Correct. While coming back, you suddenly assaulted them. Why were they suddenly assaulted? What was the facts leading up to the assault? There's nothing shown by you as to why you assaulted them. Was there some argument? Was there some shouting?
One convict, Deepak Medhi, he was in an inebriated state, in a drunken state, Then he abused the deceased and the other victims.
So Deepak is with you all. Deepak is
Yes.
one of you all, one of the convicts. So he abused whom?
Abused them.
He abused them.
This from the PW1.
Then you should have stopped your friend Deepak from abusing them.
PW1 will make.
Why did they deserve the abuse? No reason.
Well, actually, what actually had happened, they came to collect money.
Ah.
Then the villagers got them whole. Three fled away. One got injured and he expired later in the hospital.
Supposedly filled up.
Supposedly filled because the person who conducted the postmortem report also said in his cross-examination that these injuries, can be sustained by falling on some hard.
Where do we get that evidence here?
Well, PW9, page 629. The person who conducted the postmortem report. Page 29.
He is police.
No.
Postmortem report.
Postmortem.
Page 29.
29.
Yes.
First paragraph, postmortem was done in the reference with Bangapara PS GD entry number so and so. A male dead body of about 19 years wearing a jacket, genji and gamucha, medulla over the right wrist, eyes and mouth were closed, natural orifices are healthy, rigor mortis present in both upper and lower limbs. One linear aberration over the left upper shaft measuring 4 cm by 2.5. A linear aberration over the right upper chest 5 cm by 2.5 cm. The thorax,
I want to know how you have said,
yes, into
Then-
cross part,
huh?
cross.
Okay.
The time of injury has not been mentioned in the report. Such type of injury can be caused by falling on a hard substance.
And none of that. You said that these persons came to the village to collect money. And that is why the villagers got hold of them. Now, where is that evidence?
Only suggestions were put to them, but that was not proved by adducing any defense witness.
Well, how can we consider
Yes.
that aspect? If that is not in evidence, how can we consider that aspect?
No,
That is only a suggestion, that's all.
if I may take your lordship to 161, 164,
You could have asked the villagers to be defense witnesses. How many villages are there in your village? 4 only? Only you 4? Or what? You could have, there must be 100.
that should have been done,
Yeah,
man.
you could have asked your villagers to
No.
be a defense witness. Consider
For
that.
the purpose of contradictions, my lord, I would like to refer to the 164 statements, my lord.
Okay, whatever. But you see, the thing is that when you are alleging that that an act had occurred due to these reasons, evidence must be there.
Now, my lord, one thing is that it is the weapon is not seized. Secondly, there is no motive behind this. Thirdly, my lord,
You are not
pers-
disputing that the weapon was not.
my lord,
You are not disputing that weapon.
I'm saying, I'm taking this point, my lord,
Where? Did you take it during the trials?
regarding weapon.
Yeah.
That was not. No,
We'll take it
motive
up
is not clear.
We'll take it up.
Fine.
But don't take too much time, huh?
No, my lord. Well, there are contradictions, my lord, in the evidences of the PWs, my lord. Basically, PW1, PW2, 3, and 5, my lord. PW1, PW3, and 5, my lord, they were the victims along with the deceased. What they say, my lord,
They're the victim? PW.
1, 3, and 5,
Ah.
they went to bring the battery, my lord, along with the deceased.
So what movie were you going to watch?
Well, it is the
Other side
other
of
side.
going to watch.
Well, the PW1, man.
We have already gone through
Yes.
again.
I'm saying the pointing out the contradictions.
Okay.
man.
Yeah.
The PW1, man. The firstly, he says, my lord, he saw Kandarpa and Deepak assaulting Pradeep, my lord. Thereafter, he says, my lord, I did not notice as to who had assaulted whom. PW2, my lord, he is one of the friend of the victims, my lord. He went to the place, my lord. I would like to take also to the 164 in this regard, with regard to PW2, my lord. Page 19, I'm sorry, page 14.
Yeah.
Page 14. Then I went there in a run and saw that Torun was assaulting Pradeep by tying him up with a rope in front of the house of Upendaka. No, he does not say before the IO regarding Torun was hitting, man. And if we come to the page 90, the 164 statement of the PW2,
Page?
page 90. In 164, they maintain a similar version, my lord. I'll read the first part, my lord. Around 6:30 PM on so and so Nizam Boro and Bishitra Boro came to our house and informed that Upen Kondorpo and Torun and Deepak were assaulting Pradeep.
Who is this person? Page 90. Who is this person?
He is PW2.
Two.
Name is Alambar Ramsey.
Page 90. W2.
Father's name is same Madhur Ramseri, Milo. Alambar. Initially, in PW, Milo, it says Alamba. Ramseri, here it's Alambar.
Okay, then.
The father's name is same man.
Then.
Were assaulting Pradeep Boro on a road, and that they had also tied Nizam and their hands with ropes, and that they had fled after untying the ropes. Their hands were tied, initially. I accompanied by Nizam and others rushed to the spot immediately, and arriving there, we saw that Pradeep was lying on the road and Torun was assaulting Pradeep on his chest with lathi. Now, coming back to page 14. Here it says, then I went there in a run and saw that Torun was assaulting Pradeep by tying him up with a rope in front of the house. After arriving there, we untied the knots, which is quite different to the 161 version, PW3,
What about 161?
161.
161, what does he say?
Yes, my lord. I'm coming to the cross of PW2, my lord, page 14. Police examined me on the following day of incident. It is not a fact that I did not state before police as well as before magistrate that Torun had assaulted Pradeep by tying him up with a rope. Now, my lord, page 32, the cross of the IO.
No, I'm not on that. I'm not on the cross of the IO. Okay, anyway, you have to.
In 161, my lord, he did not say that Torun was assaulting the Pradeep.
No, but is there a 161 statement?
Not to be
Give the case report. Let us see the case.
Right. PW2.
161 of PW2.
Two. In cross of the IO, my lord, he says, my lord, witness Alambar Ramsiari, PW2, during his 161 CRPC statement did not disclose Torun assaulted Pradeep by tying. This is improved.
But then that means the.
No,
But
he
then
did not even take the name of Torun.
Where page?
Page 32. Page 32. In the cross part, my lord. Page 32 cross part, witness Alambar, my lord, 4 lines below, man. From 4 lines from the top, second paragraph, cross part. Witness Alambar Ramsey. Am I with the lordships?
Yeah.
Witness Alambar Ramseri during his 161 statement did not disclose Torun assaulted Pradeep by tying. It should be tying.
Well, you see, when you tie up.
No, he did not even take the name of Torun.
Huh?
In 161, the PW2.
No, let me ask you one simple thing.
Fine.
When you tie up someone, does it mean assault? Tying up someone and assaulting someone is different.
That assaulting Pradeep by tying him. He was already tied. Thereafter, they were assaulting. Torun was assaulting. This is the statement of the PW2. Page 14.
You see, supposing I say that I have tied you up, or I have tied him up, does it mean that I have assaulted him?
No. Here it says, my lord, was assaulting Pradeep by tying. Pradeep was tied earlier. Thereafter, he was assaulted. This is the statement. Tying up doesn't amount to assault, but after tying up, they said Torun was assaulting. This is an improvement what has been made in while giving the evidence. That was not in the 161.
But assaulting is there. Assaulting is there.
In 161, they said they did not see who assaulted whom.
No, that 161 we will see from what the additional.
Sorry.
Yes, madam, is it there?
It is there.
What does it, what does?
ওপৰত উল্লেখ কৰা ঠিকনা সত্য মই বৰ্তমান চোৰেঞ্চ ঘটনাৰ দিনা 21-3-2010 তাৰিখে সন্ধিয়া প্ৰায় 5:30 মান বজাত মই আৰু মোৰ লগত কেইজন শ্ৰীমল আৰি গাঁৱৰ নামটো আলম্বৰ ৰামচিয়াৰী উল্লেখ Lordship, he have mentioned that তেওঁৰ বেটাৰী থকা বাটত ৰৈ থকা অৱস্থাত ঘৰত উল্লেখ কৰা আদি লগ হৈ প্ৰদীপক বেয়াকৈ মাৰ ধৰ কৰাৰ ফলত প্ৰদীপ বাগৰি মাটিত পৰি যায়। প্ৰদীপে গাঁৱৰ ৰাইজে প্ৰদীপক মেডিকেলৰ লৈ যায়।
What does it mean?
That persons have beaten him, then he fell down on the ground. Then he was taken to hospital.
No one's name is mentioned.
Oh, yes,
No name has been mentioned there. Nothing, not regarding to tying up, Torun assaulting someone.
Names are given.
No.
Names are
No, not given.
log. Munna Torun মাৰধৰ কৰি
They have named this.
Munna, oh, they have named Munna Deka.
Deka, Purple Deka, Upin Deka, and Ronga Buddha.
that is
All of them.
All of them. They have mentioned all of them. And in evidence, they come and say only Torun was assaulting.
That's fine, but they said let
And-
all these people.
And there is nothing with regard to tying up. That is the first statement.
but little discrepancy.
Yes,
but
but
they have
that is what this contradiction is all about. My lord.
They have
That is
name all the
improvement. These are the improvements. Later in the evidence, they come and improve their
Only
statements.
tying part, but otherwise assaulting.
Assault is there.
Assaulting by all of them, but here they come and say only one person is assaulting after tying him up.
They assaulted who? All assaulted, only the deceased or the others also?
They have mentioned about the disease in here.
Only deceased.
Only this is. PW3, my lord. Nizambara, my lord, says, my lord, in cross part, I did not know as to who had assaulted whom. It was dark at night and at the time of incident, I raised the alarm. About 50 persons gathered there. I did not know as to who had assaulted whom. Only fight went on, but he fell down as someone assaulted him.
Where are we?
Page 16, man, cross part, PW3.
Correct. He fell down as someone assaulted him. Correct. What is wrong? When someone hits you, either you fall or you stand. Some persons are strong enough to still stand.
But
some
PW2
fall.
he is stating that he was tied up.
So,
Tied up.
tied up person can either be standing or on the ground also.
But at the same time, he says, I do not know as to who had assaulted whom. And in the exam, chief part, they mentions the name specifically. In cross part, they say, I do not know who assaulted whom. PW5, my lord, I will take, my lord. Page 21.
Where?
At the time of, I'm reading at page 21, my lord. At the time of incident, Bisitra Nizam, deceased Pradeep, and I were present together at the place of occurrence. Accused assaulted Pradeep Boro with their hands and sticks. The accused person dealt with blow on the head of Pradeep, as a result of which he got fractured and blood came out. Pradeep fell down on the ground as a result of the blow. Now, the cross part, my lord, it is not a fact, my lord, fourth line.
Yeah.
It is not a fact that I did not state in my statement before police that the accused person had assaulted Pradeep with bamboo sticks. Now I take your lordships to page 32, where the cross-examination of the IO. He is Sonaram Boromala. I'm coming to page 32. Witness Sonaram Boro. Cross part of the IO. Page 32. 5, 6, 8 line from the top. Witness Sonaram Boro.
Yeah.
Witness Sonaram Boro during his 161 statement did not disclose that near the house of Kondorpo the occurrence happened. The witness also did not disclose before me that the accused person assaulted Pradeep by means of a bamboo stick. The bamboo stick is an exaggeration, my lord. That is improved in the evidence, my lord. But
Let us see the 161 statement. What? PW5.
PW5.
It is there, it is there.
Sonaram Boro, আগৰ ফালে চা। And this part is,
But the same-
they are controverted with this
Look
part.
at the next sentence.
But the said witness stated that the accused person assaulted Pradeep Boro. The witness did not disclose before me that blood was oozing out from the head of Pradeep Boro.
No, he doesn't mention everything that what he ate for breakfast or whatever.
No, my lord, that is the crux point, my lord. In the 161 statement, they say nothing about it. In the, when coming to give the evidence, they say the blood was oozing out, there was fracture,
What was statement?
and when they were being hit by a bamboo stick.
Regarding
Statement of
Sonaram Boro,
Five.
PW5.
in his 161.
Yes. ওপৰত উল্লেখ কৰা মতে মোৰ নাম ঠিকনা সত্য বৰ্তমান মই পঢ়ি আছো যোৱা ইংৰাজী 21/3/2010 তাৰিখে মই মোৰ লগত প্ৰদীপ বড়ো hope you Lordship understands Assamese.
No,
Lordship,
brother will
Yes.
translate it for me.
on 21/3/2010 মই মোৰ লগত প্ৰদীপ বড়ো নিজাম বড়ো বিচিত্ৰ বড়ো গধূলি প্ৰায় 5:30 বজাত 3 নম্বৰ চিমলাবাৰী নিবাসী উপেন ডেকাৰ ঘৰৰ পৰা চিডি চোৱাৰ বাবে বেটাৰী আনিবলৈ যাওঁ উপেন ডেকা ঘৰত মানুহ নথকাত আমি উপেনে ডেকাৰ বাবে ৰৈ থকা অৱস্থাত মুন্না ডেকা আহি আমাক বেয়াকৈ গালি পাৰে মুন্না ডেকা came and rebuked them পিছত মুন্নাৰ লগত কন্দৰ্প ডেকা উপেন ডেকা ৰঙা বুঢ়া আহি আমাক মাৰপিট কৰে আৰু আমি পলাই যাওঁ যদিও
All assaulted.
Yes. প্ৰদীপক মাৰি মাটিত পেলাই দিয়ে
Other three ran away, but
Yes. আমি গৈ গাঁৱত খবৰ
No,
দিয়াত
this
গাঁৱৰ মানুহে প্ৰদীপক লৈ যায় আৰু বাগান পাৰ মেডিকেললৈ পঠায় মেডিকেলৰ পৰা নলবাৰীলৈ পঠাই পিছত ভঙাগড় মেডিকেলত প্ৰদীপৰ মৃত্যু হয়
Now the discrepancy is, my lord, they have come here and made the improvements to establish their case.
Assault is the same. 161 years said now here also. What difference?
But with regard to what they have said, my lord, they are saying, my lord, blood is coming out. They have been hit by bamboo sticks. These things are not there. These are all improved here. All these are improved version, my lord.
Forget about the blood, but the fact that he was assaulted is there.
But now the question remains, my lord, who made the fatal blow? My lord?
Very difficult. Supposing 100 people hit you, you cannot.
No, it was only 4 persons.
Even if two people hit you, you won't know whose blow was the most fatal blow.
Now
Very
to,
difficult.
now to bring in 34.
Forget about 2 people. If one person hits you, you cannot say that the 5th blow was the fatal blow or the 50th blow was the fatal blow. How will you know?
But here it says only one blow. Blow at the back of the.
Correct. Only one blow is enough. But what I'm trying to say is, which blow, the 3rd blow or the person with the second
Now
person's blow was
here
fatal?
only one blow.
Huh?
Only one blow.
One blow.
One blow. The informant has said, well, they have hit with the stick on the back of the head. And medical evidence says there is hemorrhage in the front part and linear abrasion on the chest.
Huh?
Linear abrasion on the chest. All this points out that he fell down. Linear abrasion.
Give me another 5 minutes. Complete. What more do you want to say on this evidence?
No, what I'm pointing out the contradictions in their statements and the inconsistencies. They're totally inconsistent with the 161, 164 and the evidence. So this itself is good enough reason for the acquittal.
So,
Because 161 and 164 cannot be related for the purpose of conviction, only for the purpose of contradiction.
Just a minute. 164 statement is given by whom? All the witnesses have given 164 statement. Or who has given?
4 witnesses.
The 4 witnesses.
1, 2, 3
and
and
5.
5.
They have given 164. Is it?
1, 2, 3 and 5.
So there is contradiction between their evidence, their 164 and 161. That's it.
Yes, because in evidence this is all improved version, manner. And I tried to see whether the hemorrhage manner says the bleeding inside the body or outside the body. But here I will submit my lord, it is inside the body because the scalp is contused. The report says the scalp is contused.
Counsel, the doctor who is an expert says that there is hemorrhage.
Yes. The hemorrhage is whether internal or external.
Now, did the doctor say it was internal?
Because the same doctor says the scalp is contused.
Can be contused. You see, just because it is contused does not mean that hemorrhage has to be internal. It says external hemorrhage. The word uses external. My brother has pointed out.
Yes, and same page.
Now you tell me, if it is external hemorrhage, what does it mean? The hemorrhage was inside, internal. The doctor has said external.
For the purpose of argument, I'm saying.
No, it's not for the purpose of argument. It's a purpose of it's how you look into a statement of fact made by a doctor. Unless you say that you're a better doctor than that doctor, and that external means internal, then that's a different thing. But when the doctor says external is external, it has to be accepted as external.
Saying external malad, what I'm trying to project is, they say the medical report says it is scalp is contused. Contused meaning they are without breaking the skin. If the skin is not broken, malad, the blood cannot come out.
I'm sorry, I don't think so. What is the meaning of contused? Ask Dr. Google again, or Uncle Google.
AD black.
Or let us see the dictionary. I don't think it points to the fact that the skin is not broken. It just means that this will be the dictionary. Give me Webster's, anything.
Right hand part. Top, contused.
To bruise, to injure, or to disorganize a part of without breaking the skin. A bruise and injury to an external part of the body by a cancer without laceration and either with or without a tearing, but in the form it is more properly called a contused wound. Okay.
So if there is no breakage of skin, blood coming out.
Yes. You see, yes, they're confused. Ah. To confuse means to bruise, to crush. It doesn't talk about skin out here. Doesn't, and out here, the contusion is only with regard to the skull. But with the skull, there's a depressed fracture, frontal lobe, fracture at right side.
There will be front part. Temporal is the area above the ear.
Anyway, continue.
Witness,
Anyway, we understand what you're trying to say. There was no laceration of the skin. There was contusion according to, and so there's no blood flowing out.
Yes.
Okay, that's all. Then what else?
The same thing, my lord. PW5, he has said, my lord, that fractured and blood was coming out, but he did not say before the police that blood was coming out. Now, whether these evidences are trustworthy, my lord,
Okay.
with these contradictions, my lord. Now, IO's cross-examination is important, my lord. He have said, my lord, all these things.
Okay, then
If I may read the IO's cross-examination one time.
yes. Okay.
It's 32 minutes.
Yes.
I received the Azahar.
Yes.
I received the Azahar on 21/3/2010, but time is not mentioned. On the very day I visited the PO is the Elaka of Assamese people, Bisitra Boro, the PW1. During the 161 statement did not disclose that he took Pradeep Boro to the medical. Witness Alambar Ramseri during 161 statement did not disclose Torun assaulted Pradeep by tying. Witness Sukram Boro during 161 statement did not disclose the name of the accused. The witness Sonaram Boro during 161 statement did not disclose that near the house of Kondarpo the occurrence had happened. The witness also did not disclose before me that the accused person assaulted Pradeep Boro by means of bamboo stick, but the said witness said that the accused person assaulted Pradeep Boro. The witness did not disclose before me that blood was oozing out from the head of the Pradeep. I examined Revati Deka, who is one of the injured. I record the statement of adjacent neighbors, Upan Deka, Amina, so. So all the witnesses, my lord, these three prime witnesses, PW1, PW3, PW5, they have made improvements, my lord.
We have made improvements. Okay.
And one thing I would like to say, there is no motive has been clarified, my lord. And for culpable homicide amounting to murder, there has to be some intention, my lord. But intention that is not been clarified.
But what Supreme Court has said regarding that, if there is an eyewitness, motive is not that important. It's only when there's circumstantial evidence.
Now,
Then only.
whether with these contradictions, my lord, whether the eyewitness evidence is acceptable, whether it has the credence to be.
We'll see. That we will see.
And as my lord, 34 cannot be brought into, my lord, because from the evidence, my lord, common intention, my lord, prior meeting of minds is not clear, my lord. As there is, my lord, there is no the weapon being seized, no motive being clarified. So it could be under 304 part 2, my lord. Because there is no intention behind the act, my lord. And the medical expert also have said the injuries that been sustained by the deceased, my lord, that can be sustained by falling on a hard object also. These things may be technical.
Okay, anything else?
With regard to discrepancies, my lord, if I may place it. ওটা বলেছ শুন এখানে বাকি দুটো বলেছ প্যারা 27 মানে প্যারা 27 মানে
Yes.
Generally, in criminal cases, discrepancies in the evidence of witness is bound to happen because there would be considerable gap between the date of incident and the time of depositing the evidence before the court. But if these contradictions create such serious doubt in the mind of the court about the truthfulness of the witness and it appears to the court that there is clear improvement, then it is not safe to rely on such evidences. And coming to paragraph 32,
Yes.
5 lines from below, minor variations.
Yes.
Minor variations and contradictions in the evidence of an eyewitness will not tilt the benefit of doubt in favor of the accused, but when the contradictions in the evidence of the prosecution witness proves to be fatal to the prosecution as case, then those contradictions go to the root of the matter, and in such cases, the accused gets benefit of doubt.
Yes.
And with regard to section 34, where prior meeting of minds is required, if I may place it. Get a photo of that. Abdul, sorry. Paragraph 48 onwards, man. This is with regard to 34. Man. Section 34 carves out an exception. 49, man.
Yeah.
Section 34 IPC carves out an exception from the general law that a person is responsible for his own act, as it provides that a person can also be held vicariously responsible for the act of others if he has the common intention to commit the offense. The phrase common intention implies a pre-arranged plan and acting in the concern pursuant to the plan. Thus, the common intention must be there prior to the commission of the offense in the point of time. The common intention to bring about a particular result may also develop on the spot as between the parties with reference to the fact of the case and circumstances existing thereto. The common intention under section 34 is to be understood in a different sense from the same intention and similar intention or common object. The person having similar intention which is not the result of the pre-arranged plan cannot be held guilty in the criminal act with the aid of section 34. I'm reading paragraph 30, undoubtedly 51, madam. Undoubtedly, the ingredients of section 34, that is, the accused had acted in furtherance of a common intention, is required to be proved specifically or by inference in the facts of the case. But that has to be proved, but none of the evidence, my lord, makes it clear that there was a pre-arranged plan or prior meeting of minds, man. That has to be proved. Here, one more judgment of earlier is relied, page 278, paragraph 55.
78.
275. 55. That is Virendra Singh, my lord. Section 34. Section 34 does not create any distinct offense, but it lays down the principle for constructive liability. Section 34 stipulates that the act must have been done in in furtherance of a common intention. In order to incur joint liability or for an offense, there must be a pre-arranged and premeditated concert between the accused persons for doing the act actually done. Though there might not be long interval between the act and the premeditation, and though the plan may not be formed suddenly. Now, all these things has to be proved by the prosecution. But none of the evidences say that they had a meeting of minds or they had a pre-arranged plan. So 34 they cannot be roped in with the help of the section 34. Further, there is no motive is not clarified. The mother weapon is not seized. There is no intent on the part of the convicts. None.
Lordship, first of all, Lordship, I would like to say that the opinion of the doctor, Lordship, in the PM report, Lordship, that is due to coma, page 105, Lordship, as a result of the injuries to the head described. And Lordship, as PW1, PW2, and PW3, Lordship, and PW5. PW2 also to some extent, he have also said that, but it was tied and assaulted by the accused, Lordship. And especially the PW5, Lordship. Lordship, page number 20. Lordship already have gone, Lordship, still the incident, 1, 2, 3,
Yes.
fourth line. The
Yes.
incident took place at about, it took place around 6 p.m. That is said by PW1 also, Lordship. The timing, Lordship. Timing PW1 also have said it is 6 p.m. And it was yet to be dark, Lordship. Then, Lordship,
They have been, you see, the issue is, they have been convicted under which section? 302?
302,
Is it read with 34 or what?
Lordship. That's it.
Page 82.
Lordship. Lordship.
What was the common intention that they had?
That is, one was in the drunken state.
Who was the drunkard?
Lordship, that,
Deepak Das.
Lordship,
Pradeep. Who?
Deepak, Lordship.
Deepak, the deceased.
No, Lordship. Pradeep is the deceased, Lordship.
Pradeep is the Deepak. Deepak is who? Deepak. There are too many names. in this.
Munna Deka, Lordship.
Yeah, Munna Dekha. That
Munna Dekha.
one of the convicts.
Lordship. And one have also
Was drunk.
abused, Lordship. He was drunk. And Lordship, one more.
But what was the reason that they? What was the reason that they assaulted these persons?
The reason is defense also have not put, Lordship, that there was some,
Just for the fun of it.
no suggestion that it was the accused where there was some fight or nothing is there.
That regarding that they went to collect money. And
That is not,
that is not.
not there, Lord. That is also not there. Only that is that they went to bring the battery and
The way back.
on the way back they have abused.
Who has abused?
Lordship, there is, just now I have,
Deepak Mehdi has abused.
Lordship. On my way, page number 10, Lordship, last line. On my way, I met Deepak and he was in an inebriated state and hurled abuse on us.
Oh, so because of that, a fight ensued.
Oh,
It was a fight.
it was a fight.
So there was no premeditated plan to do something.
But there is eyewitness, Lord.
No. Assault is there.
Assault is there.
But the initial cause for the fight appears to be a quarrel.
Quarrel. For abusing them, the quarrel started. And while they started assaulting, Pradeep fell down, then other two ran away and called the villagers.
Is it a kind of sudden quarrel or it was?
Lordship, it was due to abuse. The quarrel started, but the reason is not pointed, Lordship. Only the reason is that they went to bring the battery without finding they came back. On the way they.
So maybe 304.
Lordship, they knew all the four will attack a single, all four persons assaulting a single man. That also in a portion of
Four against one. Is
four
it?
against one, because two ran away. Four and
Oh, initially.
a fight ensued thereafter. Kandarpa and Deepak assaulted Pradeep. On seeing them engage a fight, I went to my house. That is Lordship Bisitra. Bisitra seeing a fight PW1. He went to house. The assaulted Pradeep fell down on the road. When Pradeep fell down, we got frightened and therefore we went to the villagers. Only one was left. Other three
They ran away.
ran away. Two went to call the villagers and one went to the house. Back to him. And three eyewitnesses.
No, I'm not on that.
Lordship, the
I'm on
reason,
the-
cause of
I'm on the
fight.
issue of whether
30
what was the reason for the entire episode? You know?
issue, Lordship.
Yes. Who had started the fight? Was there an intention to really kill? Or it was a spur of the moment, issue?
That is that
Because
is
it
not there
appears-
that there is earlier animosity or
There
that
is
is not
nothing, there is
Nothing
no
is- it is-
animosity. So it appears that there was a sudden
fight.
was some I don't know, shouting at each other, must be something incident. There was a fight.
Lordship.
Then the two ran away.
Two ran away. One went to
Two left.
four were there, Lordship.
Uh,
One came back to his home. Two ran away and called the villagers.
and
And one was beaten.
uh,
One was assaulted. And the thing is that all the witnesses, eyewitnesses, that corroborates with the medicals.
no, that's all right. That's all. Was there any weapon seized?
Fracture.
Any weapon seized?
That is seizure, Lordship.
Was the what is it, bamboo sticks or what? What is this?
Bamboo.
Bamboo, danda. So they were not seized.
Not seized, Lordship.
In fact, my existence of bamboo stick is also doubtful. Because the person who says with a bamboo stick, that was not said before the police. That is an improvement made in the evidence.
I don't know. Every time you say that is not said before the police, you read the police cross-examination in 161, it is always there. Every time.
Not with regard to the bamboo stick. Bamboo stick is not there. That is improved and at the stage of evidence. Not even 164.
So this bamboo stick was not mentioned in the 161.
164, Lordship. I'll see about 164, Lordship.
164 was mentioned.
PW5 or something. So,
Science. Pradeep was PW, Lordship. Alambar Ramsiari Lordship, page number 91. Pradeep was lying on the road and Tarun was assaulting Pradeep on his chest with lathi.
91.
91.
He's
Six-
top-
160.
And Tarun was assaulted Pradeep.
With
Who is
lathi.
Tarun?
Tarun is Lordship,
One of the convicts, man.
Rangapura. Rangapura Lordship.
So you are representing all
No,
of
man.
them, right?
All
You are
Lordship.
representing all of them.
Tarun is Rangabura.
Rangapura Lordship.
But next to like, you can't argue that like I'm only arguing from Tarun.
No, I'm not.
So saying Tarun, no, because now all the people.
Yeah, I representing all men. Here it says assaulting Pradeep on his chest with lathi. If you assault someone with lathi on the chest, people don't get linear abrasion. Linear abrasion is if someone skids on the ground, then there will be linear
Lordship,
abrasion.
Nizam Boro Lordship, PW3. He also said that in page number 93, in 164, has taken along.
So who has been seen, which of the appellants have been assaulting the deceased with the lathi?
That is
One is Tarun,
Tarun.
then. But in
Then
the evidence,
Kandarpo had taken a long lathi and arriving there. They start Kandarpo also, Lordship. Page number 93.
This is it, all four of them assaulted.
All four of them assaulted. Nine.
no.
No, a little later, Munna arrived.
Madam, this is a statement under 164. I want to see the evidence. In the evidence,
Or evidence.
who has been identified as assaulting the deceased?
Lordship.
PW2 says Torun was assaulting Pradeep by tying him up. He says in the evidence, but
Tying
not
him up is not assault. Tying him up is tying him up.
tying him. But that was not stated in 161. This is improvement made in the evidence.
How long have you been in jail?
3 years, 6 months.
Since the
Date of judgment.
huh?
Date of judgment, man.
Prior to that, you were on bail.
Yes, I was there for 3 months, man.
Huh?
During investigation, 3 months.
UTP? 3 months.
3 months.
3 months. Then 167. You were released on 167.
Yes.
Default bail.
Default bill.
Then since then you have been in jail.
Right.
Since the judgment.
Yes.
PW5, Lordship.
Yes.
Page number 21. The accused persons assaulted Pradeep Boro with their hands and sticks. Third line, Lord, fourth line. Page number 21.
And this. But no sticks have been seized.
No seizure is not there. Also, as regard this Lordship, 3 eyewitnesses are there, Lordship. And medical is totally corroborative with the eyewitness that it is assaulted, head injury is there. And doctor opinion also corroborates it. So my submission is that Lordship, this is judgment may be uphill, Lordship. And in regard to the eyewitness, I'll place on judgment, Lordship. Kartik Malhar, Lordship, I have given Lordship, para 11.
Okay.
Para 11.
But 34 doesn't seem to, 34 cannot be applied here.
Lordship.
There's no common meeting of.
Lordship.
Correct.
Lord.
whether 304 is affected.
Lordship, this is up to you, Lordship, because
No,
there is a.
No, that,
No, that,
no, I'm asking.
Lordship, because three witnesses, Lordship, there are eyewitness, they are saying that that is not in evidence, so I cannot, Lordship, I will not go to that extent, Lordship. But as it is read from the evidence, it is seen that there was a quarrel. But the reason of the quarrel is not here.
Nothing is here as to how it went out of control. Nothing is here.
That is, Lordship, because quarrel was, the issue was the battery, then there was abuse, then fight started. And they knew, Lordship, 4% attacking a 1%. That is there, it is clear. And they have hit on the head, so he fell down, getting injury in his head.
Let us see, let us see. Let us see what happens.
Here, though prosecution is saying that there are three eyewitnesses. Now, whether these eyewitnesses, their credibility is required to be examined by them, because there are a lot of discrepancies, as I have pointed out.
Well, the fact remains
That he was.
that the death has occurred. And there are a number of witnesses that saw. Whether it was accurate, the manner in which he was hit at the back of the head, the front of the head, all those are issues that are not very relevant.
My lord will also come.
You see, there are going to be discrepancies here and there.
It is bound to be.
The thing is that how the fight started and was there no weapon seized, nothing. So whether 302 can be attracted, that is all we think. Because prima facie it appears that 304 for sure.
That is for
That is for sure. But whether it can also attract 302. That is the only thing that is bothering us. Because there's a lot of things missing. Lot of things are missing. How nothing is there in the beginning. The only thing that is there that people have seen this. That's all. Though not very clearly, but it is there. That cannot be denied.
My lord will also mark the improvements they have made, my lord. My lords will mark the improvements they have made in their evidences. They come and say in the 161, 164, they nowhere say that there is blood, they have been hit by a bamboo stick. But these are improvements they have made in the.
Well, whether they've been hit by a bamboo stick and all, yes, those things we have to see. But
the informant says the bamboo.
But then the fact is that there was blood. When the doctor says there is an external hemorrhage, that means there has been blood has come out.
And the same doctor has said that these injuries can be sustained by falling on a hard substance.
Maybe that is always there.
That also,
doctor will say, will give you, if you want 10, 20 reasons, he'll give you 20. That is there.
Those part also needs to be considered.
Always they. So,
you assaulted, that much we know. There is no going around the bush in that. Only thing is whether 302 will be attracted, that's the only thing.
The motive is missing, my lord. Other weapon is.
So what? There is eyewitness, where's the requirement of motive? It's only when a case is to be decided on circumstantial evidence, then motive plays a big role. Out here, there's eyewitness. What more do you want? All right. I think you don't push your luck any further. Otherwise, we might be seeking otherwise. We have heard you, I think, 4 hours already. Yes. Heard, Mr.
PK Monday.
PK Mangal, learned counsel for the appellant. Appellants. Also heard Ms. A. Begum, additional PP. The present appeal has been filed by the 4 appellants who have been convicted under section 341/302/34 IPC by the court of the Sessions Judge Mushalpur in Sessions case number 249 of 2008. While judgment dated 20/01/22 and have been sentenced to undergo one month simple imprisonment each under section 341 CRP. They have also been sentenced to undergo rigorous imprisonment for life with a fine of ₹1,000 each in default, further rigorous imprisonment for 2 months under section 302 IPC. Right. The prosecution case in brief is that an FIR was lodged on 21/3/2010 by the informant number 1, Mridul Pathak, by the informants Mridul Pathak, number 2, Shri Ratia Boro and Shri Pabin Swar Gyari. On 22/3/2010. No, 22/3/2010. No? 10. To the in charge Bagan Para out. The FIR stated that around 6 p.m. on 21/3/2010, 4 boys, namely number 1, Shri Sonaram Boro, number 2, Shri Bichitra Boro, number 3, Shri Nijan Boro, NIJWAN, WA. Boro, and number 4, Pradeep Boro, all residents of Simla Bari village went to the house of Upen Deka to take the battery on red. As they did not find any member of they did not find Upen Deka or his family member. They went back. On the way back, the present appellant assaulted the 4 boys with sticks, due to which Sri Pradeep Boro became unconscious on the spot. He was immediately shifted to Baganpara Hospital, wherein the doctor referred him to the Guwahati Medical.
It was brought lordship from there.
Guwahati Medical, that's all. Guwahati Medical Hospital must be.
GMC it's one.
Was brought to the Guwahati Medical College Hospital, where he succumbed to his injuries. Pursuant to the FIR, Barbari PS case number 17 of 2010 under section 341/302/34 IPC was registered. After the investigation of the case was completed, the IO submitted the charge sheet, having found a prima facie case under section 341, 342/302/344, 34. 341, 42, 302, 34 IPC against the four appellants here. Next one. The learned trial court thereafter framed charges under (341/34) and 302/34 IPC against the appellant, to which they pleaded not guilty and claimed to be fact. The learned trial court thereafter examined 10 prosecution witnesses, and after examining the appellant under section 316 CRP, the learned trial court came to a finding that the appellants were guilty of committing the offense under section 341/302/34 IP. They were accordingly convicted under the said provisions and sentence was awarded to them as has been referred in the foregoing paragraph. As referred to earlier. Next paragraph. The appellant's counsel submits that there are contradictions in the evidence of the four eyewitnesses. Actually, there are four, no? Not three. Four eyewitnesses. Four eyewitnesses.
PW 1, 2, 3, and 5.
That is the PW 1, 3, 1, 2, 3, and 5. He also submits that the prosecution has not been able to bring out the motive for the appellant to have allegedly assaulted the deceased, someone who had as deceased, deceased, Pradeep Goro, someone who had subsequently has expired in the hospital. The learned counsel for the appellant also submits that though the witnesses have stated that in their evidence that blood had been coming out from the head, yes, from the head, blood was coming out from the head,
Yes.
from the head of the deceased. There was nothing in the inquest report to show that blood was coming out from the head of the deceased. He also submits that the evidence of W2 is to the effect that he saw the appellant Tarun Medi alias Ranga Burj, Ranga Burj, Ranga Bura, Ranga Bura, assaulting the deceased Pradeep Rama by tying him up with a rope in front of the house of Upendek. However, PW2 had not stated the setback before the police under section 161 CRPC, as well as before the magistrate under section 164 CRPC. Next paragraph. He also submits that, continue, huh? He also submits that the evidence of PW3 Yes, what do you want to say about PW3? Their names are mentioned here. Pandar, Deepak, Upen.
He's one of the victims, madam. Here, what I want to point out, madam, that he has named the accused persons. But in the cross part, madam, he says, madam, I did not know as to who had assaulted whom.
Okay. Saurabh, sir. In his examination in chief, has named the appellants as the persons who had assaulted the deceased. Mr. However, in his first examination, PW3 stated that he did not know who had assaulted whom.
And his statements are also not 164 and evidence are not corroborating.
I've already said all that. Next paragraph. The counsel for the appellants also submits that PW5 had also stated in his examination in chief that the accused person, that the appellants had assaulted the deceased Pradeep Boro with their hands and sticks. And they had also dealt a blow on the head of the deceased, as a result of which his head got fractured and blood came. However, the said fact was not informed by PW5 to the police. In his 161 CRPC statement. Correct?
Mine.
Yes, sir. He submits. No, continue. He submits that the testimony of PW 1, 2, 3, and 5 is an improved version of the statements given by them under section 161 CRPC and 164. Correct?
What they have said in 164 is Upendekar tied their hands, but not in the evidences.
Comma. He also submits that in their 164 statement, the witnesses, the PW 1, 2, 3, and 5 have stated
1,
that
3, and 5.
1, 3, and 5 have stated that
Their hands were tied by Upendekar.
that the hand that the hands of the that their hands were tied by Upendekar,
But the said fact was not
which was not testified by them, stated by them during recording of their evidence.
contradictory.
During the recording of their evidence, that means he also submits that. Next part. The learned counsel for the appearance submits that there was no intention on the part of the appearance. No, they're done. The appearance counsel submits that. Even if it is assumed that the appellant had assaulted the deceased, there could have been no intention to kill the deceased. Especially when no weapons were seized by the police. He also submits that section 34 IPC cannot be attracted to the facts of this case, in as much as there is no evidence recorded to show that there was a prior meeting of mind or having a common intention to kill the deceased. Next paragraph. The learned counsel submits that when the discrepancies in the statements of the witnesses are major in nature, the said, what was that? 2017.
27.
What do I think? Yeah, then it would not be safe to. Then it would not be safe to rely on such evidence. In this regard, they relied upon the judgment of the Supreme Court in the case of Christian Gowda and others versus State of Karnataka by Arka Good Police, 2017, 13 SCC 90. He also submits that. He also submits that. Section 34 IPC cannot be applied to the facts of this case. In as much as there is no evidence to show that the death of the deceased had occurred in furtherance of a common intention of all the appellants to kill the deceased. In this regard, he relied upon the judgment of the Supreme Court in Abdul Saeed versus State of Madhya Pradesh, 2010, 10 SCC 259. Any other citation you relied upon? No, that's all. No? This, that's all. The learned counsel for the appellant, that's subject that the in view of the reasons stated above, the conviction and sentence imposed upon the appellant by the learned help not having been supported by the evidence adduced by the prosecuted witness of the same should be set aside. And the appellant should be acquitted of the charges framed against him. Next part. Miss A. Begum, learned additional PP. Submit that there is no infirmity with the impugned judgment and order passed by the learned trial court in view of the fact that there are 4 eyewitnesses to the assault made on the deceased by the appellants, some of which ultimately led to his death in a hospital. He submits that the 161 CRPC statement made by PW2 to the police clearly states that all the appellant had assaulted the deceased. Similarly, the statement made by PW5 in his 161 statement to the police also shows that all the appellant had assaulted the deceased. As such, even if the cross-examination of the IO shows that, no, is to the effect that PW2 and 5 did not state before the police that the appellants did not assault the deceased from a reading of the statements made by PW 2 and 5 under section 161 CRP clearly proved the fact that they had stated before the police that the appellant had assaulted the victim, the deceased. Next part. The learned additional PP subjects that the minor variations and contradictions in the evidence of the witnesses cannot tilt the benefit of doubt in favor of the appellant. Inasmuch as the discrepancies do not go to the root of the matter. Yes, ma'am. Yes, you had produced one judgment for what purpose?
Lordship, regarding eyewitness lordship,
Kara?
11 lordship.
What does it say? You don't, in, what is the citation?
Kartik Malhar lordship, lordship.
Is it 11 or 14?
Huh? 1, 6, 1.
Maybe 14?
14 lordship.
14, okay, right. The learned edition PP submit that when there are 4 eyewitnesses to the crime in question, there was no occasion for the court to have taken a different view than the view, then the view that it has taken. In as much as conviction can be made on the basis of the statement of a single witness, provided the evidence of that witness is reliable, unshaken and consistent with the case of the prosecution. In this respect, he has relied upon the judgment of the Supreme Court in Kartik Malhar versus State of Bihar, 1996, 1/6/1. That's all, no other judgment. The learned APP also submits that when there are eyewitnesses to the crime in question, the absence of motive does not play any role to prove a case of murder. Anything else? Anything else? Any other? That's all.
Appeal lordship.
Okay. Accordingly, submit that the impugned judgment in order passed by the land trial court should not be interfered.
Lordship.
We have heard the land counsel for the party. Reserved. No time.
I may take the book back.
Oh, this one?
PW5, my lord will consider, my lord, PW5 regarding the bamboo blood coming out, not stated earlier. my lord. And this is improvement made in the evidence. And the evidence has to corroborate, my lord, 164 and 161. Nowhere they have mentioned that blood came out, being assaulted with a stick. All improvement here.
Doctor's evidence is there, external hemorrhage. Yes, sir. If it's external hemorrhage, it means blood has come out. But, unless you can give me a different meaning to the words external hemorrhage. If it says internal hemorrhage, okay. But doctor specifically stated external hemorrhage.
That I can take, my lord. And at the same time, they use the word confused.
There's a difference between the scalp and the skull.
And also, my lord, the PW6, which is the informant, my lord, he says that the deceased was hit with a bamboo at the back, but there is no medical science.
See, like I told you before, whether you see some persons say I see two persons fighting, say around 20 meters away. Now, I cannot say with accurately where he hit. It might appear to me that it is on the back of the head or the side of the head. It might not be. It might be that he missed the head also altogether. Might be. This we cannot say accurately. It depends upon where the witness is standing, angle is standing. A lot of things are there. It doesn't have to be precise. When you see a boxing match, Mike Tyson and all that.
I can get it, man.
No, I'm just telling you, supposing you see them fight, you might think that they have hit on the right shoulder. They might have, in fact, hit on the stomach or the liver, that kidneys or somewhere. I mean, you cannot say.
What I'm trying to project.
Not say precisely. That does not.
That cannot be said if it is hit on the stomach and getting hurt in the liver. man. But what I'm trying to project is they say that it was the disease was hit at the back, and the medical report says the frontal bone has been back and front. That is what I'm trying to project is he fell down and the injury in the chest. That's linear abrasion. That cannot be by blowing with a blows or.
So your case is that they quarrel and he fell down.
He fell down, and
He died due to head injury.
He died due to falling down.
How the head injury has been caused, my lord.
So according to you, there were 4 persons here, 4 persons here. 3 of them ran away, 1 left, and while they were quarreling, he fell down and he died. Because he hit his head on the
Some hard
stone.
substance. Because there are abrasion in his chest. And
Do you believe what I've said? Does it sound believable? Look, you've got to think as a common man.
It says linear. Why I'm making this?
4 eyewitnesses.
Why I'm making this submission is because of the linear abrasion. That cannot be. Linear abrasion can be there only if it skids.
Assault part is there. That it not come out of that.
We'll see.
Yes, ma'am.
We'll see if you can come under 304. Because it appears that it started from a quarrel. It started from a quarrel. And the problem is.
Nothing is seized.
Nothing is seized. You see, it's in a village. You are in their village.
There.
Bad mistake.
No, the people from the Boro community came to the village of the Assamese community.
Oh, okay. The other way.
Yes.
They came to your village. But your village caught you out. Your village people caught you. Then you're in a worse position then. Your village people caught you.
There was no difference witness.
You're even in a worse position now. So your community people not helping you. They are saying that you are the one who is causing trouble. I didn't know that. Now, now,
Those-
huh?
Those
I think we should say too much. Let us leave it like. Okay, reserve.
obvious, my lord.
What? Okay, no, I know. Yes. Timing item 9. Now, what is, no, this is what, appeal against acquittal, huh?
Yes, ma'am.
Or by whom? By the,
Conviction.
huh?
Conviction.
Appeal against conviction.
Conviction.
We'll admit the appeal, what is it? Miss,
Yes, Your Lordship.
your name,
S. Hazarika. Lordship.
Miss S. Hazarika. Appearing, no, counsel for the appellant. Submits that the impugned judgment dated 5/5/2025 passed by the court of the addition sessions judge comes special judge Poxo Morigaon in Poxo case number 127 of 2023 arising out of Morigaon PS case number 197 of 2022, by which the appellant has been convicted under section 6 of the Poxo Act, should be set aside. Full stop. Admit the appeal, call for the trial court record. Issue notice returnable in 4 weeks. Ms. B. Buyan, additional PP, accept notice on behalf of the state.
Yes,
Uh,
my junior will accept notice.
Notice be issued to the respondent number 2 to the office of the PP and OC of the concerned police.
We have to serve a scan copy of
Who
the,
is to serve? The appellant shall provide a scanned copy of the appeal.
along with IA, Your Lordship, along with IA,
What-
interlocutory
okay.
application.
That's approved. That copy of the appeal along with the IA to the office of the PP through the registry or to
No, true.
to the office of the
PP.
PP, to the office of the additional PP. This is the matter after 4 weeks. Then in the IA, you write, this is an application under section 430 BNSS for suspending the sentence. Ms. B. Buyan is granted 4 weeks time to file written of it. This is the matter. What is the next? I'm being item 30.
Sorry, my lord, I was on legs, my lord.